just outside of that courthouse where this decision was made. We welcome in Madison Schlegel once again. Madison, good to see you again. Welcome back. And before we get to Ed Booth, any more updates that we need to know?
Yeah, no exact updates. I mean, you've heard that we've gotten sound from both the prosecution and the defense in this case. Again, we've got the backdrop of the Newport News courthouse behind us. Connor, last time we spoke, you had questions about some of the statements that Abby Zwerner's lawyer passed along, as well as also some concerns about why the judge kind of made the decision that she made here in the case. And luckily, to help give us a little bit more insight to that, we've got legal analyst Ed Booth with us right now. And Ed, thank you so much for making yourself available for us and coming out, joining us here in the field to talk about this case. I mean, in hearing that the judge has dismissed these 8 counts, knowing that you've been following this case for 3 years, what was the first thing that went through your head on a legal basis?
Well, as any lawyer would think, the judge has taken the case away from the jury, which happens both in criminal and civil cases. But as soon as you hear that ruling as a lawyer, you understand that the judge has considered the facts in the law as put on by the Commonwealth and decided that the jury doesn't need to hear the case because those facts and that law, or the combination of the two, don't equate to something that should go to a jury. In other words, the judge is going to say, I'm going to take this away and make a ruling, essentially direct a verdict in favor of the defense because certain elements or certain aspects of the case wouldn't merit allowing it to go to a jury.
Right. And I think over the last couple of days, we've also seen some confusion from the jurors as well. We remember on day 2 or day 3 of the trial, we were hearing for a possible mistrial because of the jurors possibly asking questions about what was actually put on the record. When you hear that there were so many stops and starts in this case because of hearsay, because of what the statutes were actually allowing for the defense or the prosecution to bring to the table for the witnesses, what comes to your mind when you hear that the jury was kind of already questioning the information that was put on the table when they didn't even see all the evidence yet?
Well, sure. I mean, as a trial lawyer, when you're putting a case on in front of a jury, I mean, things don't always go exactly the way that you hope. That's just not the reality of trials. But, you know, a smooth progression of the evidence and something that makes sense and is easy for the jurors to follow is the ideal, right? That's what we want. And when you get something less than that, the more confusing it becomes for them, the harder it is for them to process the evidence. But ultimately, they didn't have to make any decisions because the judge essentially made the decision for them and granting the motion to strike that the defense made.
Well, I think we may have seen a little bit of an inkling of that yesterday when that motion for a mistrial came up, because obviously that was presented by the defense, but it was the prosecution who said, I actually think I agree with that. And that's what caused the judge to go into recess for a bit. So knowing that there were kind of agreements in the confusion or the instances that were laid on the table from both attorneys, both sides here, is that kind of common in a case like this, especially when we've got a case that's so contentious as the one that is here?
It's not super common. I mean, sometimes one side wants a mistrial, the other side is opposed. Occasionally, you have something where, both sides are kind of like, okay, we got a problem. I mean, that can happen in both civil and in criminal cases. Is it real common? No. I mean, generally speaking, one side saying, please give us a mistrial, the other side saying, no, you don't need to do that. Whatever happened, because happen for a lot of reasons, right? Whatever happened isn't bad enough or serious enough or doesn't warrant granting a mistrial, and that the trial should continue. Now, I wasn't there yesterday, but my understanding from what you just told me is that the Commonwealth is saying, well, okay, that could be an issue. So, clearly there was at least some common ground in terms of what had happened during the conduct and course of the trial that at least gave both sides a little bit of concern. But it sounds like, ultimately that wasn't granted, and the judge went on to grant a motion to strike, which is a different motion entirely and an important one typically made in criminal trials.
Well, that was going to be my next question for you. I just want to get kind of some clarification for the people at home on what this truly means. This decision doesn't mean Ebony Parker is guilty or innocent here. It kind of just means that the judge has found that there's not enough for this case to kind of stand on, correct?
Well, yeah, it's called a motion to strike the evidence, but basically it's a motion to dismiss the case because the prosecution hasn't met whatever the elements of a particular crime crime are. So, I mean, think of it, we call it a motion to strike, but in essence, it's a motion to dismiss. So, that kind of motion is always made by the defense to say, Judge, we don't need to go any further. We don't need to put on any evidence. We don't need to have a jury consider anything because the elements of the case aren't here. I mean, I'll give you a perfect example. I mean, if somebody was charged with arson, but the Commonwealth failed to prove, that the fire occurred by arsonist means, in other words, was intentionally set, that's a core element of the crime. And if you fail to prove that, well, that case shouldn't go on to a jury and a defense shouldn't have to put on any evidence. So it can happen for a lot of reasons, but it's very important because jeopardy has attached, witnesses have been sworn. So, this is the end of the case, but it's the end of the case because the judge has said that there was something that wasn't met in terms of the prosecution's proof.
Do you think that this might open the door for another case? Is that something that could happen here? Or do you think that since this has kind of been the decision, this issue won't be brought up again in the courts? Could the Commonwealth bring it up again?
Well, it's double jeopardy applies. I mean, when you swear witnesses and begin the trial, that is the trial. And people aren't tried twice for the same crime or set of facts and circumstances. So, no, I think this is the end.
So even if they were to, given the basis that it was standing on those 8 counts in the indictment that were brought up, could the prosecution potentially come up with different indictments, or again, is that something that's not really typical in this kind of case?
I mean, you're getting into some pretty esoteric legal grounds, but the idea is that if you're going to charge someone with crimes based on a certain set of facts and circumstances, you do it all at once. You don't get to pick away at different pieces. I mean, the idea is that we don't find different ways to try people for the same set of facts.
Well, and that's exactly why we have you here today to answer those kind of questions, because I know that those are things that are milling around in the minds of the people who are watching this trial unfold. But we also kind of heard from Abby Zwerner's attorneys today too. They had referenced that civil case that had happened last year where she was granted that $10 million, and also an issue of insurance that the city was kind of claiming as well. I know before we got on camera here, you gave me a little breakdown about what that means in a case like this and how what came out of this case right here could possibly play into a factor of that. Do you just mind giving me a little snapshot?
Well, sure. Criminal and civil cases are very different. What happens in a criminal case doesn't necessarily impact a civil case. Sometimes admissions made that are part of a criminal case can sort of carry over into a civil case, but generally speaking, they're separate. You have an independent result in the one, and it's separate and apart from the other. But as to your question regarding insurance, when you have a government defendant, a school system, there's basically 2 sets of we'll call them insurance companies. They're labeled a little bit differently, but for all intents and purposes, that's what they are. When you have a defendant who's been charged with or convicted of a crime, sometimes those insurance companies effectively will say, well, no, we're not going to provide a defense for you. We're not going to give you a lawyer. We're not going to provide indemnity if you were to be found responsible for that conduct. I've seen it happen in my cases before, and criminal charges are one of those bases here. So that effectively removes conviction of a crime from an argument that could be made, in favor of not providing insurance. Now, the charging is different and the conduct is different, but at this point there is no conviction.
Well, we heard some of that kind of argument come from the defense yesterday when the parents of the children who were inside that classroom took the stand yesterday. One of the biggest questions that the defense asked every single one of them was, do you have something to gain from a civil case that you have now filed in this situation? Do you have something to gain from a conviction in this case, in that civil case? And many of those parents said no. And I think it begs the question of really, even though Abby Zwerner's civil case has been wrapped up, we know that on the back burner there's this other civil case with those parents that's still open, that still hasn't been heard yet. How do you think that this outcome today will impact those cases moving forward?
Well, I don't know that it will impact it in any meaningful way other than what we just talked about in terms of potential impacts on the coverage. The questions that you described, they're kind of classic bias questions. It's, do you have kind of a dog in the fight? Is there something that could happen here? And sort of the reverse is true, right? Because, on the one hand, if the conduct is the same, those parents might say, well, we want to see justice, or words along, that line. But on the other hand, if the goal is to have a recovery in a civil case for a child, well then, you want a source of funds to get that. I mean, it's sort of like, if you're in a car accident and the person who hit you doesn't have any car insurance and you don't either, well, that's a problem, right? And that, you've got kind of a double-edged sword here. But the questions that you described, it's classic bias. Do you have a reason to want an outcome, and you always hear that in criminal and in civil cases.
The last kind of question I've got for you before I turn it back to Connor to see if he's got any questions in-house courthouse for you. The judge also said directly in this case that there's no precedent to follow here. Obviously, over the last 3 years, we kept hearing the word, this is an historic case. Knowing that with the background of what we've heard today and knowing what's unfolded over the last 3 years, not that this is necessarily a bow on it at all, but what would you say about how the lack of kind of precedent or other cases that have been seen like this, how that impacts what we've seen today as well?
Well, it's just obviously it garnered the national attention that it's garnered because of how unusual it is, and then of course the criminal and civil cases that have spun off of it. So yes, it is unusual. It's not the kind of garden variety, case involving children and abuse and neglect and endangerment that you see, unfortunately all the time. I mean, we have those cases every day. They're being heard right down the street, and nobody has an interest in them because it's just sort of garden variety awful things that happen in society. But this is different. The charging mechanism is different. The theory of the case is different. So in that sense, there isn't a playbook that that a prosecutor or a defense attorney can go to and say, well, oh, this is what has happened in the last 5 similar trials, because there aren't any. And that doesn't mean that this can't be the first. Obviously it was. It just means that it isn't a situation where we know what happens in a case like this, because there just aren't a lot of them.
Does this lay the ground for a future case then?
Well, I don't know. I mean, I guess it depends on what your point of view is, right? Obviously the prosecution was unsuccessful, and in this particular case, it doesn't mean that a case under a similar theory couldn't be charged in the future. These are all independent, based on their own facts and the prosecutorial discretion as to whether or not it's appropriate to bring charges. So prosecutors will continue to do what they feel is right, which is seek justice for convictions that they feel like they can reasonably obtain on the evidence. That's their role, and defense attorneys will defend those cases. That's theirs.
Perfect. Well, Ed, this conversation here is so helpful. I know not just for me, but I'm sure for the people who are watching back at home too. And Connor, again, you've heard some of that analysis there about why the judge made the decisions that she possibly did. I just want to ask you, obviously we've got Ed here for us. Do you guys have any questions back there in the studio that maybe you'd like me to ask him?
Yeah, absolutely. This is going to be something unique for us. I'll relay the question to Madison. She'll relay it to Mr. Booth, and hopefully we'll be able to get an answer. We heard Stephen Teague, one of the defense attorneys, talk about how he has seen this in misdemeanors. He has not seen this in a felony trial. I'm wondering why that is the case. Why is this even more rare for a felony trial, for us to have this conclusion, for this motion to strike to be approved by the judge?
Yeah, the defense attorneys in their questioning outside when they came out of the courthouse basically said that they've seen this happen in misdemeanor cases, but not technically felony cases. Can you give us a little bit of insight about that?
Well, I wasn't there and I didn't hear their comments, so I'm not sure exactly what facts or circumstances they were talking about. Can you give me a little bit more information on what exactly they meant in the distinction between felony and misdemeanor?
Yeah, because these were felony charges that were brought against Ebony Parker. Because of that, he said that this was the biggest case, one of the biggest cases that he's ever got to try.
Right.
So in the past, he's mostly seen this kind of situation play out in a misdemeanor kind of scenario. So watching this play out on a felony type of level, is that rare, or is that different, or is that maybe to be expected?
As I understand the question, obviously it's a felony, so it's a much more serious charge. It carries the potential for more serious prison time. It's tried differently. Misdemeanors are tried in front of district court judges, and that's a trial in front of the judge rather than in front of a jury. The presentation of the evidence is different. You don't have jurors and the considerations that go along with that. Everybody there knows the rules of evidence, and and you have a judge who's able to sort of disregard things that are inadmissible and consider things that are admissible. So in some sense it's a simpler case to put on. When you put on a felony charge in front of a jury, there are a lot of considerations that go into that. So I think maybe what they were saying, if I understand it correctly, is that we've seen theories like this more often appear in cases where the consequences were comparatively less. I think maybe that's the best way to interpret it.
All right. Well, Connor, there's your answer via our game of telephone. Hopefully I relayed that properly for you. Do you got any other questions or qualms that you would like me to ask Ed Booth for you?
I do. And my qualm is that I have to keep doing this to you, Madison, where you're kind of listening and repeating. But in terms of questions, right? when we saw that confusion earlier in the case, jurors were confused, which led to lawyers having some questions. A lot of it came over the objections due to hearsay, what was on the record, what wasn't on the record. I know that Mr. Booth was not in the courtroom day in and day out, but does that confusion on day 2 and into day 3, what role does that play in this decision here? How big of a factor was that in the judge making this decision?
Yeah, we touched on that a little bit, but I have no problem asking that kind of question again. Connor's just basically curious. Obviously, we mentioned the confusion that the jury had about what was being struck from the record and what was able to keep on it. In the sense of knowing that there was confusion amongst the jury, does that kind of speak to the fact that the prosecution maybe didn't lay the grounds properly about what they needed to be defending here?
Well, it doesn't necessarily mean that. You have a lot of cases in a trial where, something is said during a witness's testimony, and the judge strikes that and says the jury will disregard that. And the extreme example when something is said is, okay, we're going to go ahead and grant a mistrial, we're going to start the whole thing over again. And for some very serious things, constitutional violations, that's really the only remedy. You have to grant that mistrial. But there are some things where the court may say, like, I'll give you an instruction on that. You're not to consider that. And we have to trust that the jury is going to follow the judge's instructions. And when the judge says you're not to consider these things, you're only to consider these things, that the jury is going to follow what the judge said. So, you have layers of, of sort of corrective action that a court can take. The most extreme being, the mistrial. There's nothing that we can do to fix this. It's broken beyond repair. We have to start over. The more mild is don't consider that. That's not something for your consideration. I know you heard it. We can't unring the bell, but you're not to consider it, and then we have to trust that the jury will follow that rule.
All right, Connor, substantial enough answer for you?
That was more than substantial. My last question for you, just from what is it like to be a lawyer who has been involved in a case like this and is now walking out of the courthouse? I mean, what is that feeling like, win or lose, to have reached this conclusion, to have put in all this work, and then to get a ruling like this and be walking out of the courthouse trying to grapple with all of that?
Yeah, obviously over the last 3 years this has played out, and for many of these attorneys, they've lost sleep over this, hours and hours that it takes to put together a case like this. And knowing that the answer that they got today was that this case was going to be dismissed, if you put yourself into the mind of the attorneys that were walking out of the door today, maybe either side, the defense or the prosecution, what would you say about maybe their feelings about knowing how big, how fruitful this case was, and then kind of having that lifted off their shoulders in just a moment?
Well, I mean, that's the life of a trial lawyer. I mean, if you try cases in front of juries, you've been there. You felt that. You felt it on all sides of it. You do the very best that you can do. You put on the case that you can put on. It's ultimately either in the hands of the jury or in the hands of a judge. And at the end of it, you got to look back and say, I did everything that I could do with the evidence and the facts that I had. These were the decisions that are made, and we've got to accept it and move on. I mean, that is our system, right? You got to go and you put your case on. You do the best you can, and a judge or a jury decides it. And yeah, I mean, there's amounts of time that are put into it, money in many cases. That's true in civil cases and in criminal cases. So, but that's the job, right? And I'm sure that they were having all the thoughts that those of us who try cases in front of juries have: disappointment, excitement, depending on which side that you're on, and then you move on, and there'll be another trial.
The air of acceptance, yeah, definitely. Acceptance we've seen on both sides of those parties today. Again, we heard from Ebony Parker that she feels grateful for this decision. And in the case of Abby Zwerner, she still feels like the city of Newport News has disregarded her actions, the actions that led up to that day. So again, the acceptance in this case kind of falls on both ends of the spectrum right now. But Connor, that's what we've got to give you here. If you've got any more questions, I will field them to Ed Booth here. But in the meantime, we're going to keep you updated on everything that's happening and work to put all this together for you to make sense of it for not only our noon broadcasts, but also our evening broadcasts as well.
You guys are the best. Ed Booth, Madison Schlegel, we appreciate you so much. Thank you for the game of telephone. Thank you for all of that insight. And Madison, thank you for your work all week on this case. And I'm sure we'll see you later on this afternoon.